One of the things that we'll talk about, and that reason that IP is becoming so important, is because a very high percentage of the entire net worth of companies like Coca-Cola and others is their intellectual property. And some of them as much as like 95, 98% of the entire net worth of the company is the intellectual property that they hold. And the joke in Atlanta is, this is just sugar water. And anybody could sell sugar water, but they've managed to accumulate enough intellectual property to really protect it and make it an extremely valuable and profitable company. So the types of intellectual property broadly, patents are useful inventions. I think everybody kind of has a feel for that. But I wanted to give you a contrast so that you could see how they all fit together. Copyrights are expressions that are fixed in a tangible form. Trademarks identify the source of a good or product, a good or service, and then trade secrets are confidential business information that's kept confidential. So it's really often a combination of all four of these that make a company's intellectual property very valuable. It's very difficult for a company to have one and not at least one or two of the others to really have the total package for protecting their technology. And then marketing. I mean, you could protect it with just patents, for example, but it's very difficult to market something without the trademarks that go with it. Apple's technology wouldn't arguably sell at the same price points if it didn't have the Apple or the iPhone or the other i trademarks on the product. So a patent is a set of exclusive rights that's granted to a user for a limited period of time. And one of the points that I think, if you could take this away, is a really important distinction to make, is the patent doesn't give you the right to do something. What the patent does is it gives you the right to exclude others from doing something. And that can be really, really key, because if you have a patent that is an incremental improvement over technology that's already patented, that doesn't necessarily mean that you can practice what you've invented without infringing someone else's patent. So anyway, the key here is that a patent gives you the right to exclude others from doing something, and it's the current period that a patent is alive is 20 years from the filing date. There are some exceptions to that, particularly in the pharmaceutical field, because it often takes a patent a long time to come out of the patent office. You can sometimes recover some of that period at the end if the patent office has taken too long to process a patent. But generally, it's 20 years. So the rights that you get under your patent are the right to exclude others from making, using, selling, or offering to sell in the United States, or importing into the United States the invented invention or the invented product.